r/Askreddit. Lawyers of Reddit, what's your best most baddest I rest my case moment? I was a second-year associate and handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a completely bullshit examination of the issue, and his expert report was equally as bullshit. For those of you that don't know, expert testimony needs to meet a certain standard, the Dorbit standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Dorbit motion to strike his report/testimony because the case was low value, under $100K, and those types of motions can be very complex, and didn't want to bill the client for it. I was so angry about this guy being deemed an expert that I came in on a weekend on my own time and drafted a 20-page motion to strike his testimony. I didn't bill the client a dime. The defendant didn't file a response to my Dorbit motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate, just like me, do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second expert witness, who was pretty terrible, but not quite as terrible. I also did his cross-exam. Realizing that they were in serious trouble without their primary expert, and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck except for one very tiny area. So essentially he was forced to testify with both hands tied behind his back. It was the most gratifying moment of my legal career so far. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the element of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. So I call up my client's disgruntled former employee about a contract dispute that he started, and that got my client into litigation. After 2 questions, it was obvious he was a lying son of a bitch. I didn't want to call him as a witness. He was prone to act unpredictably. I took down his story as we talked, which was easily proven false by documents, and which cast my client in a false and bad light. I did not tell him how I'd caught him in lies. Fast forward one day, I submit a list of known witnesses to opposing counsel, as required by the rules. Witness number 1 was the lying sack of shit. Fast forward to trial. My opposing counsel calls the lying sack of shit as his first witness and the lying sack of shit acts like a lying sack of shit. He tells the same story on the witness stand that he told me on the phone. I took emails that he wrote and entered them into evidence and proved him a clear liar. My client didn't breach the contract, the party suing did. After the lying sack of shit left the witness stand, I asked the court for a brief recess. Granted. I approached opposing counsel. My client was still willing to sign on to the walkaway settlement, where no money changes hands, and no fault was admitted. We offered the deal 2 months before, and it was angrily rejected. Now, suddenly, it was accepted. Score. I do mostly solicitor work, so if I'm doing my job right I don't get a whole lot of these type of moments. That being said, I had a long time client who was being sued, and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete/confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out, or he can find himself another job. He takes the latter option. But he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. I represented a man in a slip and fall case in a national chain that grills chicken. The restaurant is not supposed to clean the grills until after they close because it is a huge sloppy mess that involves using a garden hose after applying chemicals to remove all of the grease. The close down process can take up to 2 to 3 hours that involve parking up the food for the next day, scrubbing the grills, mopping, etc. Even though the corporation knew this, they refused to pay more than 1 hour worth of wages after closing time. Thus, the shift managers and cooks decided that they would start the closing process 2 hours before closing, while there were still customers in the restaurant. This is really dangerous as employees delivering food can track the greasy water into the lobby where the customers were. On one fateful day, 2 hours before closing, one of the cooks was cleaning the grills and using the hose to wash them down. This slurry is so slick that the cook has to wear a plastic smock and slip-resistant shoes for the process. While he was waiting for the chemicals to remove the grease, which takes about 15 minutes, the cook goes into the lobby tracking this stuff into a hallway to wipe down some tables. My client walks out of the restroom and slips in the greasy water. He hits his head so hard that it causes a subdural hematoma which requires surgery to relieve the swelling and blood from the brain. Go figure, the video system wasn't working that day. In any case, right after that the cook was fired and the corporation claimed that they could not locate him during litigation. I did some research and found a relative of the cook, which eventually led to me finding him. He admitted that he was cleaning the grill, but denied that he was the one that tracked the greasy water into the lobby, as did all of the other employees. The corporation during the entire 3-week trial testified that cleaning before closing was against their policy and it never happens. Thus, it had to be anything else that caused my client to fall. I was talking to the cook before trial because we were going to call him as a witness. He was pissed that they fired him. I asked, "Do you think they are still cleaning before closing? Because they are denying that they do." He told me, "Absolutely." On the first day of trial, I sent my investigator to the restaurant at the time my client was injured, which was 2 hours before closing, to record video on his cell phone, whether they were cleaning or not. Guess what? They had the hose out and everything. I couldn't believe that they would continue to do this at the restaurant at issue in the case. I told my investigator to go back up there when there is a different shift manager and cook to see if they are doing the same thing. They were. At the end of the trial, the defense put on their general manager for the region. He swore up and down that this never happens. He was their last witness. We get up and say, "Judge, we need a sidebar." In the judge's chambers we revealed the videos to the other side. The attorney for the corporation was freaking out. The judge let it in for rebuttal. The last thing the jury saw before going into deliberations was 5 minutes of video with audio of the hose as they were cleaning the grills 2 hours before closing. We completely wiped out their entire defense in a 3-week trial with that video. Needless to say, we prevailed. I should add, using sub rosa video against a defendant like this is very rare. They usually stop doing what they are not supposed to be doing during the trial. I guess the restaurant didn't get the memo. Edit. Typos/correction. It wasn't a trial, though we had one of those, and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks, that is notes he took during class. He is furious and sues the landlord in small claims for $5,000, state maximum, because his notebooks have such huge value apparently. They hire me, and I respond, which moves the case out of small claims. It's just the way it works here after time in r/legal advice. I know this is not the case for every state, but our rule is better than yours. But enough aside, this puts him at a huge disadvantage, because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, no, that won't be happening, and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned. Period. End of story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won. I was helping a client gain custody of his infant daughter. He insisted that baby mama was on drugs, and his first attorney tried in vain to get him to understand just how favorable our state is to 50 over 50 time, unless he can prove by a pretty high standard that she was on drugs. The problem is that he kicked her out because he had suspicions, but then one day found needles and a substance in the other baby daddy's bedroom. This was all wrapped up in an old dish towel with a band, the type you put around your arm for shooting up, name, and a spoon. She tells him every fucking lie. Don't know, not mine, only tried once, etc. But he refuses to believe her and kicks her to the curb. So he fires first attorney and hires me, and I go straight into client control mode, heavily managing expectations while doing everything I can to put requirements in place to catch this drug use, and we are getting nowhere. The trial problem we have is it's a one-time thing. She's a good liar, even by legal standards, and we have nothing current to show a pattern. But he insists, so I file to restrict her time and we go to court. She's such a good witness and the judge buys every bit of it. On cross she testifies that she only ever shot up the one time ever, and that's the only time she ever used anything illegal, and she just knew how to shoot up because she didn't know. I thought I had a pretty good cross. It took some time, but I felt like we got what we needed. But we lost, and the judge gave her essentially 50 over 50 time, ordered us to mediation, and set up some regular drug screens. We go to mediation and put in place a parenting plan that sets up a little more detailed 50 over 50 custody schedule, but also requires regular urine drug screens and some more detail about those screens, so we can be sure she isn't constantly trying to beat the tests. Best I can do with the facts. I caution him that all we can do is pay attention to the screens, stay on top of it, and take her into court under an emergency motion at the first slip up. But she is so good. She's supposed to take the screens within 24 hours of a request, but always has an excuse and is just a couple days or so late. Also somehow almost all of her screens are on Wednesdays. Later find out a friend works those days. Also, mysteriously, she refuses to give me direct access to the screens, but provides them to her lawyer who faxes them to me. I immediately start sending faxes. He was old school, no emails, and an asshole, so no phone calls, and telling him I consider this contempt, and he better cure it, or I will file. My client is furious at each contempt, but the standard for this is so high, and we've already been in court once, and didn't do well, so I really needed to build a case. So finally we get quite a few weeks of ridiculous behavior, and my more than reasonable attempts to address it with her attorney. I file for civil and criminal contempt and we go to court. An important detail is that she has another baby daddy who was fighting custody at the same time for the same reasons and has required drug screens. I'd been in contact with his attorney and we were sharing information. I find out that the night before our hearing she had completed a urine drug screen and passed it. So when we get there I caution my client about getting his hopes up. Remind him this is a long game. She's late and judge starts without her. No fucks given. Her attorney surprise withdraws. He says it's because of lack of communication. She finally shows up as I'm giving the rundown of my motions. I run through the timeline of missed screens, delayed screens, a screen that failed because her sample was too diluted, etc. And the judge looks at her and she gives all the excuses in her very sweet and innocent way. The judge listens, then asks how she would test that day. She says she will be clean. So they screen her, and she fails for exactly what we expected. The judge asks why, and she tries what are clearly excuses this time. Changes her story to fit the facts, and he cuts her off and tells her he doesn't believe her. He orders her to 4 hours a week supervised visitation, and she has to pay dad support until she completes an intensive outpatient drug treatment program, at which time she can regain some of her custody. That little girl just turned 5 and mom has never visited, and to my knowledge, has never completed any treatment. She also hasn't paid a dime, which my client doesn't care about, and doesn't care to pursue. It's a small town. He said he saw her in a restaurant once, and she walked right by her daughter, and didn't acknowledge her. I've seen her out once with friends partying without a care in the world it seemed. Sorry for typos and if garbled. Had to get in before my plane takes off. I've had a couple such enjoyable moments, though they have all been no further questions moments, as I rest my case is not something I get to say in family court. I apologize in advance for what is likely to be a pretty lengthy post. In the first ever domestic violence restraining order (DVRO) case I had as a new attorney, I represented a woman who has broken up with her ex-boyfriend after he has shoved/hit her. She filed for a DVRO when he continued to harass her and show up uninvited to her place. The process for getting a DVRO, at least in my state, is the victim files documents describing the alleged abuse, and a judge decides to grant a temporary restraining order, with a hearing scheduled within a couple weeks, where each side can present their case. Even after my client got the temporary restraining order, her ex continued to try to contact her, including randomly showing up where always she took her dog for a walk at 5 AM the morning of the hearing, even though this was 25 miles away from where he lived. At the hearing, even before either party got to testify, the judge reiterated that any violation of the temporary restraining order, including attempted contact with the victim, was grounds for a permanent DVRO being issued. The judge ended up ordering a brief recess before we were to introduce evidence/testimony. During the recess, my client went to the bathroom, and the ex decided it would be a good idea to follow her into the bathroom to talk her out of pursuing the DVRO. He had not noticed that the bailiff was also using said bathroom, and the bailiff immediately ordered him out of the women's bathroom and threatened to arrest him. When we got back into the courtroom, X took the witness stand to testify. I asked him if he had just attempted to enter the women's restroom to make contact with my client. When he answered affirmatively, I smugly stated that I had no further questions. The judge tore him a new one, and the DVRO was immediately ordered. On one other DVRO case I handled, I was defending a husband who was accused of completely unsubstantiated and clearly fabricated abuse by his train wreck of a wife. My first question for the wife, when she took the witness stand, was, isn't it true you made these allegations and are requesting this DVRO solely for purposes of gaining an advantage in custody and support proceeding? I obviously assumed she was going to deny it and was really just planning to try to get her angry on the stand so she'd slip up and give inconsistent or conflicting testimony. When she answered yes, the judge looked as surprised as I was. I immediately stated that I had no further questions, despite the fact that I had prepared at least 40 to 50 questions for her, and sat down. The judge tossed the case moments later. A lawyer friend of mine had this scenario. His client moved into a newly built office building where they got to do a fair amount of construction work to arrange the offices on their floor how they wanted. As it turned out, there was this overly large gap between the lip of the elevator door and the floor, on the order of an inch or so. You wouldn't think that's enough for an issue, but it was leading to people continuously tripping themselves up. So, since they were doing construction anyway, they paid someone else to do a small concrete pour to smooth things out and fix the problem. The original construction company finds out about this and uses their technically unconcluded contract to insist that they can rip up that floor and fix it themselves. They do so, and now instead of a small issue next to the elevator, the entire surface of the elevator lobby on that floor is ruined. Random +/-half-inch dips and hills all over the place. There was basically no leveling of any kind done. Upon being told that this was unacceptable, the construction company responded by sending the client a bill for the first redo that they hadn't wanted done since they'd solved the problem, and a quote for fixing it. The timeline of these events was presented to the court, and then an extremely scientific presentation on just how truly horrid this floor was, with high-resolution topographic maps of the surface presented, clearly showing just how bad this floor was. And then the lawyer, while talking with the lead engineer for the construction company, leans in and asks the question, is this acceptable work for your company? The reason this is such a mic drop is that it is handing the construction company a win, but at great cost. If they say yes, then the client has to pay the first bill and would have to pay for a redo, but then the lead engineer of that construction company goes on public record as stating that shoddy work is considered acceptable by the company. If they say no, then the construction company eats the cost of the redo and the redo necessary to fix it, and goes on record as saying they screwed up. Not a lawyer, but was working with our corporate lawyers on a patent infringement case. I was an engineer specializing in the technology in question, a document scanning system. At the time, we had a relationship with a company that provided OEM products for our lower end scanning market, and in the meantime we were working on a higher end machine of our own design. As our new design was getting ready for market, they accused us of violating one of their patents. The wording of the patent in question was very broad, and it indeed looked bad for us. They invited us to their HQ to discuss the issue and potential remedies. Best case, licensing fees. Worst case, back to the drawing board. We had met several times before the trip to prep, and despite the efforts of our engineering team, we could not find a hole in the patent. We flew out to their HQ, and upon landing, met one more time in the hotel lobby. We were prepared for the worst. It was then that I noticed some wording in the patent that was quite specific about the way that the document scanning surface was held in place while the scanning head moved. Their patent described the surface resting on fixed rails, with the scanning head moving beneath it. However, because we were very concerned about maintaining a constant focal distance from the scanning head to the document, our scanning surface was captured by the head itself, not the rails, so that the document surface would freely track any minor up and down. or twisting motion of the head due to rail deflection or dirt, or what have you. In fact, if the head was not present in the machine, the scanning surface would just fall into the bottom of the unit. Well, the lawyers looked at me in shock. We talked it through, and they started grinning, and soon we were all smiling like idiots. It was bulletproof. We went into the meeting. They had their corporate lawyers, engineers, and business sector managers, and after all the righteous outrage was expressed, along with the desire to somehow find a way forward and maintain a good working relationship, blah blah blah, it was show and tell time. Our lawyers simply said we don't believe that we violate your patent, and using the prototype that we had brought along, I showed them why. It was beautiful. They just sat there at first, then their technical guys asked me to show them again, then they left to have a private conference. We just tried to keep it professional while we waited, but we knew we had them. They came back all apologies, saying how they hoped that our fruitful partnership could continue as it had been so successfully before, etc. When we left we went straight to a nearby bar and celebrated. By the end of the night, our straight-laced corporate attorney was all "I love you guys, man." It was a great day. Several years ago there was a big drug bust in my town where the cops arrested about a dozen people in this garage and charged them with manufacture/delivery/possession with intent to deliver a controlled substance, drug dealing, conspiracy, and criminal organization known as RICO in other places. I was appointed to represent one of the people found in the building when the drug task force raided the place. The police filed an 8-page affidavit of probable cause. Most are 1 to 2 pages for most other cases, detailing their surveillance of this criminal enterprise and the comings and goings of various participants and their roles in the enterprise. I read all 8 pages and realized that the only place my client's name appeared was on page 7, where it said the following individuals were present at the garage when the warrant was executed: Person 1, Person 2, Person 3. So he was there the day the drug task force raided the place, but there was no mention of his involvement in the criminal enterprise. His bail was set at $250,000, which is ridiculously high, and the district attorney refused to agree to a lower amount at his preliminary hearing. I filed a motion for bail reduction and showed up at the hearing loaded for bear. The DA calls the case. I approach the front, and the judge jumps right in before I could even open my mouth. Usually counsel makes their arguments first. The judge asks any questions of us he has, then he makes his decision. The judge looks directly at me and says he's read the affidavit of probable cause. He says what is alleged in there is pretty serious and a big deal in our small town. He noted how the task force had the place under surveillance for weeks to build their case, which ultimately resulted in their raid. And if the allegations can be proven, the defendants are facing some serious consequences. But he says, now turning to face the DA, he saw that my client's name appeared only once in the entire affidavit, and it makes no mention of his involvement in the drug enterprise. The judge asks the DA why shouldn't I grant defense's motion for bail reduction? The DA stammers, we have evidence that this defendant was involved with picking up the material from Philadelphia and transporting it here. The judge looks at her again and says, did I miss that in the affidavit? She replies, no, they just recently found that out. The judge turns to me and asks me if I have anything to add. There I was, fully prepared to make this passionate argument for why my client's bail should be reduced, the deficiencies in the affidavit, my client's advanced age, his lack of a criminal record in the past 20 years, etc. I stood there trying my best not to smirk and said, I have nothing to add, Your Honor. Motion granted, bail reduced. Thank you so much for watching the whole video. Please leave a like and subscribe.